In this episode of No Holds Barred, we're going to talk about what you do when you've been sued. Lots of people have never been sued before. They know nothing about what happens. But that late night knock on your door, 9 o'clock, and there's some stranger with a parcel of papers that he hands to you and says, "You've been served." What does that mean? Well, it means you've been sued in a court of law. I'm going to talk about just state court law because it's a little easier. People do get served and sued in federal court, but today we'll talk about the rules that apply in the state of California generally, and those same rules apply really across the country in many ways. First and foremost, you're going to get a stack of papers. It's a summons and it's a complaint. Read it. Read it. Do they have the right person? Is it you that they're serving? Is it a company that you have something to do with? Is it your spouse? Is it one of your kids? Is it a stranger? It doesn't even apply to you. So read it. Look up at the top and see what's the law firm that sued you. Read the complaint and see where it's venued. Let's say you live in Contra Costa County, California. Look at it and it says in the Superior Court of the County of Contra Costa. So you know where it is. Pretty important to go through that process of figuring out what exactly somebody's looking for. It may be something you don't recall at all. Maybe a traffic accident that you were involved in, goodness, a couple years ago. In the state of California, we have a statute of limitations for personal injury actions, and it's 2 years. Of course, we never recommend that lawyers wait the full 2 years to file, but sometimes it can be as long as 2 years that somebody gets around to finding a lawyer to sue or gets around to suing. So at any rate, take a look. I remember that. It was an accident I was involved with a long time ago. But it wasn't my fault. Well, all right. Do you have a copy of the traffic collision report that happened at some 2 long years ago? But we're getting ahead of ourselves. The first thing you want to do is say to yourself after reading it, do I have insurance to cover this? So in many cases, if it's a traffic accident, an automobile case, hopefully you had insurance and you had sufficient insurance to cover the liability issues. But for certain, you want to make sure that you tender that to your carrier. What does that mean? Well, call up your brother-in-law, the broker who sold you the policy, and say, I've been sued. And that broker should say, fax over to me or scan an email a copy of that complaint. And you make sure you tender that, because that is an important date, tendering the defense, because in most insurance policies, if in fact it's covered, that date of tender is very important because all the obligations and the costs that take place from the date of tender are important. If you throw it in a pile and do nothing for several months, you're going to find out that a default may have been taken against you. And what's a default? A default is your failure to answer within 30 days of having been served. Why is that important? You have 30 days from which the date you were served to respond to that, and that response is a written answer. And for the average person, that's not something you want to do. You need a lawyer for that. Most insurance companies have their staff counsel or appoint lawyers. So the first thing that happens, that broker then takes a quick look and sends it over to the insurance company. The insurance company then assigns a lawyer to it. That lawyer gets in touch with you and says, I'm going to be handling it. I'm going to be defending you. Let's say you don't have insurance. Let's say it's a business dispute and you don't have liability insurance for your business. Do you have a homeowner's policy? Look at your homeowner's policy. Your homeowner's policy might very well cover you. We've talked about in a previous episode of No Holds Barred dog bite cases. And I've often said to people, you get sued for your dog biting somebody, go to your homeowner's policy. and in many cases it is covered. But in all cases, tender to the insurance company or tender to the broker. Now keep in mind, many insurance companies kind of, as quick as can be, deny. Nope, sorry, you don't have coverage. Never take that first denial to heart. Never. There's always a way to seek coverage many times after there's been a denial. But take a look at your homeowner's policy, your auto policy, your umbrella policy, various policies of insurance that you may have. That's a very important place to go, looking at insurance, and tender that defense. Now, what will happen is typically the insurance company will say, we need some time to look at this. And after a period of time, you'll get perhaps a reservation of rights letter. What is that? That's the insurance company has written out a letter to you stating what their policy obligations are. In many cases saying, we're going to accept liability, we're going to accept your defense, but we're not necessarily going to accept indemnity. And what does that mean? Well, we'll defend you under your policy, but we may not pay any judgment. That's indemnity at the end of it. And in that case, they have an obligation to advise you that you need to retain other counsel to look at your own personal assets in the event that they're not going to indemnify you. But anyway, all of these things are important to discuss with a lawyer. If in fact you do not have coverage, you need to hire a lawyer. We absolutely do not recommend that people go into court in serious cases unrepresented in civil cases. And certainly if it's a criminal case and you are the named party, you want to have a criminal offense lawyer, or if you can't afford one, go to the court and advise the court at the arraignment that in fact you need the services of a public defender. In any case, it is folly, and many people do it, to show up in court without an attorney. An issue comes up always, and that is, do not discuss the case with anyone other than perhaps your partner or spouse or someone such as that, because those discussions typically are not privileged. So when you go, holy mackerel, I've been sued, you call all of your friends, you exclaim, this is what happened, this is my position, all that. Those people are then subject to disclosure and subject to have their depositions taken or statements taken from them. So we always advise, keep your mouth shut. Start to gather documents. There was a traffic accident. Oh, I do have a copy of the traffic collision report. I do have some medical records. I do recall talking to the guy. Jot down and write down, if you can recall, what the person on the other side said to you. So that's just a start. But let's assume that your insurance company has denied coverage. It is perhaps a case of an intentional tort. You were at a bar, you got liquored up, you got in a fight, and you punched somebody. You actually were defending yourself, but the other side has sued you for damages. And your insurance company, let's say your homeowner's policy, is going to say, we don't cover intentional torts. But if the plaintiff's lawyer is a smart lawyer, they're typically going to have within that complaint a negligence cause of action, perhaps a defamation cause of action. There are certain triggers that plaintiff's lawyers know of, certain allegations that will trigger coverage. An insurance company will say in their reservation of rights letter, well, we actually don't cover intentional torts, so the battery that's alleged we don't cover. But we do cover this negligence cause of action, and let's say there are two. One is intentional infliction of emotional distress, not covered because it's intentional. But negligent infliction of emotional distress typically would be covered. That should be covered, and that's a little bit of the fight that you might have with your insurance company, is ensuring that, in fact, you do have coverage for at least a part of it. There's something that we call in the industry the duty to defend as opposed to the duty to indemnify. Under the law in the state of California, the duty to defend is a greater duty than the duty to indemnify. What does that mean? That means the insurance company has a greater duty to defend you than to indemnify you if everything lines up. And that means they may say, we don't have any duty, as I said before, to indemnify you, but we need to defend you. What does that mean? That means they pay for the lawyer, not you. And very important that that, in fact, take place. So, as I say, don't talk to anyone but that lawyer and explain to that lawyer what's going on. So when people come to us who've been sued and we take a look at the complaint, we see where the venue is. An important thing is we see who the lawyer is on the other side of the law firm. First thing I do is I look them up. Look them up on the state bar, make sure that they're licensed, like to see where they went to school, what their credentials are, and get a little bit of a measure of who they are. Go to their website, see who they are. Is this what they focus on? Is this that area of law? One thing I do like to say, nothing wrong with family law lawyers or any other kind of lawyer, but don't retain your brother-in-law's family law lawyer for a serious personal injury case unless that lawyer also does serious personal injury cases. So it's important and an obligation actually of lawyers to not take cases for which they're not qualified. Do they do it? Do it all the time. Do I see cases in which the person on the other side has absolutely no business whatsoever handling a case of that nature? Absolutely. So go back. You've been sued. You've been served. You got the complaint. You tender to your insurance company, and they don't pick it up, and you have to hire a lawyer. Go to the lawyer's referral service. Go out and talk to friends and see who's a good lawyer that can represent you. Now, if you have to represent yourself, that means you have to pay for it yourself, and that can be a rather pricey thing. But you have to weigh those benefits and those obligations and see whether it's going to make sense for you to retain a lawyer or get a big judgment against yourself, and you don't want that to happen. I've seen several cases where somebody got sued, they ignored it, they got a default judgment, and again, what is a default judgment? That means within that 30-day period of time within which to answer, they did not answer. And most lawyers will not take a default immediately. They'll give a little time. They may even call the person up and say, hey, you're going to answer. You're going to file a response. But after a period of time, they take a default. And you know what happens with a default? You are now no longer a party to the case. You don't get to show up in court and argue because there's a default against you. And what does the other side get to do? They simply get to prove up their case without any input from you. So a default is entered. It is first of all requested. The court enters a default. It's officially in the record that there's a default. The court sets it for what we call a prove-up hearing. It may be on the papers in which the lawyer on the other side submits papers. In effect, these are the damages, this is what it is, and have a little hearing, or actually have somebody testify. I had a case in which a fellow seriously sexually assaulted his maid over a number of years. He was arrested. He was deported. We had sued him, but he was deported, left the country. We took that default while he was still available, and then we went to a prove-up. And the judge awarded us $10 million at that prove-up. So that's the kind of peril that people can get in with, throwing that complaint aside. Don't want to do that. Don't want to do that. Make sure you get a lawyer. Now, most lawyers on the other side will always give the courtesy of additional time. So and I don't recommend spending a lot of time talking to a plaintiff's lawyer if you've been sued. You don't need to talk with them about the facts of the case or argue or, wait a minute, it wasn't me, it was his fault. No. Don't do any of that. That lawyer is not your friend. But if you have to, while you're searching for a lawyer and you haven't retained one yet, if you have to and you need some additional time, Most lawyers will give the courtesy of additional time. Call them up and say, hey, I've been sued. You sued me. I'm looking for a lawyer. I'm actually talking with lawyers, but I haven't officially retained a lawyer. Having said that, that will allow him to talk with you. If you said, I've hired a lawyer and I just want to talk with you, he'll say, I can't talk to you. You have a lawyer. I have an obligation not to talk with you. So the key word is, I have not hired a lawyer yet, but I'm talking to them, but I need some additional time. Can you give me an additional 30 days? And then put that in writing to that lawyer. You have now given me until X time. And hopefully within that time, either an insurance company will pick up your case or you yourself will hire a lawyer. What's the next step after hiring that lawyer or responding to that complaint? And again, I'm going to say, don't file the response yourself. You can, but that's what lawyers are for. And I've heard it 100 times, if I've heard it once, a judge saying to a party, a defendant in court, Mr. or Mrs. So-and-so, you need to hire a lawyer. You're up against a good lawyer who's trained. You need to hire a lawyer. So again and again, I will say, representing yourself in a civil action is not smart. Is not smart. The next step, and let's assume that you've got a lawyer and the answer has been filed. Now it's in the hands of the lawyer. The lawyer may tell you, but the nice thing is to do it ahead of time. Gather whatever documents that you have that you think will be helpful. You did a little diary. You have some notes. You have a traffic collision report. You have a report at that bar where the police came. They didn't arrest anyone, but they took a report on a battery or whatever it is. So, because your lawyer is going to want to know as much about this as possible. You broke your hand when you punched the guy, and there's some medical records, but it's defensive, you say. All right. Gather your medical records. Gather all the records that you can, that you believe will be helpful for that lawyer in evaluating your case. So that's then filed. You notice also when you got served with that summons and complaint, there's a date that says you got to show up in court. And what is that? That's the case management conference. If you have a lawyer, there's no need for you to go to the case management conference. Clients often, hey, I need to go to the case management. There's nothing to the case management conference. There's nothing that is going to take place that you need to concern yourself with. Typically, the first one is about 90 days out after the filing that is set by the court at the time that that complaint is filed. And what is a case management conference? It is nothing more than the lawyers appearing, or a party who's unrepresented, in front of the judge, and the judge will say, where are we with this? Say, well, we just answered the complaint, Your Honor. We haven't done any discovery. We haven't done anything. All right, I'm going to set it out another 90 days. Why don't you do your discovery? Come back in 90 days and we'll figure it out. So that's another case management conference that's set. If you have a lawyer, you don't need to go. Don't waste your time, because they're 2 or 3 minute little quick hearings, multiple people. You may be 10 down the line. You hear your name as a defendant. Your lawyer stands up and says, Your Honor, can we kick this over 90 days? And that's also. Case management conferences in civil cases are not particularly important. In fact, in San Francisco, they generally don't even have them. They just, if you file a case management conference statement, the court then sends out a new date. Okay, make sure you mediate by this time, or in some cases, they even set a trial. Okay, what happens after all of that? You've got a lawyer. He or she is going to the case management conference. You've been sued. You're very unhappy about it. But you've been sued. There's not much you can do about that, except perhaps defend it. You think you've got all the information that you can defend the case. All right, that's appropriate. What is next is that the lawyers on each side are going to send out, we call written discovery. So they're going to send out form interrogatories and requests for admissions and requests for production of documents. What's all that mean? Well, that means that they're going to send to the other side questions about, okay, show us what you got. Each side kind of does that. So Kind of in short terms, that's really what it is show us what you got. What I like about federal court is, with discovery, there's a certain date, and that date is, each side is obligated to produce everything that they've got. In state court, it's not quite as simple. You have to ask the questions, but there are form interrogatories that ask such things in an accident cases. Do you have a driver's license? What's the number? Do you have insurance? What's the coverage? Have you been to the doctor? What are the various names of the doctors? What are the parts of your body that were injured? Were they injured before? Have you had accidents before? All those things, that's all part of that written discovery. After lawyers get that written discovery, kind of digest it, and I do want to go back. It's my practice in every case in which a client of mine has been served, has been sued, for me, after I've been retained, to pick up the phone and call the lawyer on the other side. I'm Matt Guichard. I represent so-and-so. Just want to introduce myself. We're going to be working together. Tell me what you got. Let's talk about the case. And in many cases, that kind of breaks the ice. The other side is very happy to hear from me. And we can talk about the case a little bit. I can see this guy's just going hell-bent for leather, and this is the biggest case in his whole career. I'd like to know that. Or it's kind of a nothing case. He filed it. Plaintiff is his brother-in-law. This is how it kind of works. So I'd like to know that too. So it's very helpful. That's what lawyers can do. After all the written discovery, then we call depositions. What's a deposition? It's sworn testimony under oath. So you may be called, you're the defendant, you may be called to have your deposition taken. And there's a court reporter present. The other side's attorney will ask you questions, will describe what this is all about, and it's all done under oath, and it's all put in a little booklet by that court reporter. And your lawyer is there to protect you, to make any objections at all. But those are important things that happen in depositions because they can be used at trial. So that testimony that you give in deposition is very important because you can be impeached at trial. But let's assume, as we know, most cases do not go to trial. So let's say the court has set out another case management, 90 days. You got that written discovery done. The court says, all right, before I set it for trial, I want you to go to mediation or arbitration. And what is that? Mediation is where the parties get together with a neutral mediator who kind of works the room back and forth and negotiates and hopefully reaches a settlement. And frankly, that's where most cases settle nowadays, is at mediations. Trials take up such a small part of our whole civil system. You have a right to trial, and certainly we have trials that go. But mediations is where it's at. And as people have often said, what's a good settlement? One side thinks they paid too much. One side thinks they got too little. And it's kind of that little in the middle, very important. If the case does not settle at mediation, it gets set for trial. And that's where the rubber meets the road. And unfortunately in our system, trials have become so incredibly expensive. And that's why cases settle at mediation. You need to hire experts. That traffic case, the human factors person, the accident reconstruction person, your doctor or the doctor the plaintiff wants $10,000 for a half a day to come because he or she's got to walk away from their practice. So very, very expensive. Time-wise, you need to pay for a jury, you need to pay for these things. The courts aren't frankly happy, even though they say that they are. And nobody's happy with trial. And a lot of times, the 12 people don't return a result that you're pleased with. So smartest thing to do is to resolve that case way back at mediation prior to getting anywhere near trial. And that doesn't mean that you can't go to trial. There are a lot of times there are issues that simply need to be decided by a jury and they can't be resolved at mediation. That's kind of where we go with these things. Now, I will say at trial there are verdicts, and let's say you have a jury, and other than criminal, in criminal you have to have unanimous juries in the state of California. In civil cases, 9-3. So you can win a case if you get 9, and the other side gets 3. So, all right. So let's say you have a big judgment that is rendered against you at trial. It's something you have no ability to pay. And it's one of those cases where your insurance company, let's say it's a $100,000 policy that you have, and they pay up to $100,000, but the judgment is $500,000. And for a lot of reasons, you could argue the insurance company should pick it all up. But let's say in this case it was postured right by the insurance company, and now you have a judgment $400,000 above your policy, and you got to pay it. Well, perhaps it's time to talk to a good bankruptcy lawyer, and we certainly have people that we can refer you to for that, because that's important, looking at those various factors. During the course of the litigation, prior to getting to trial, there may be some legal issues which have been raised, which are a complete defense to you. And your lawyer then proposes filing what's called a motion for summary judgment. And the motion for summary judgment is kind of a complicated motion, but it is a motion by which the judge can look at the law and render a decision as to whether or not liability, let's say, is excluded. So motions for summary judgment can be filed by both sides. But in many cases, the defense files a motion for summary judgment to get out of a case. Let me talk about that. How would that happen? Let's say you are a city and you have been sued for allegedly a dangerous condition of public property. There's an intersection with an awful lot of accidents, and the complaint is that the city knows it has a lot of accidents and didn't do anything about it. All right, so you sue the city for a dangerous condition of public property. In most cases, under that scenario, the city gets out. And we've had that, in spite of the fact that people think it's dangerous and the city knows it's dangerous. So we had a case like that where actually we were defending a city, and the city sent engineers out regularly. They did traffic control studies. They did a number of things, and it came back from their traffic engineers and all that, in fact, the intersection was a safe intersection. The traffic control lights were properly metered. Everything worked just fine. And with their traffic studies, there was nothing that the city was responsible for, except for the fact that there were an awful lot of people that traveled through that intersection on a daily basis. And sure enough, there were a number of accidents. So we prevailed on that motion for summary judgment, and we defeated that dangerous condition of public property. So that is the kind of thing. So it can happen. Now, as we all know, and you're probably thinking, yeah, never been sued before, been sued. I just want to go tell the judge, not my fault. I like to tell people, it doesn't work that way, especially at the case management conference. Judge is really not interested in hearing what the client has to say. It's just, I got to move this through. When are you going to finish discovery? So, no, it's not as easy, and people often think it is. Just go tell the judge. I mean, you're my lawyer. Just go tell the judge that I didn't do anything wrong, and, they should dismiss the case. So the only way that happens is if, in fact, we file a motion for summary judgment, or what's called a motion for judgment on the pleadings. That can happen right at the very start. When you actually look at the complaint in it, you can file something called a demur, or maybe a little after you've answered a motion for judgment on the pleadings. I don't want to get too deep in the woods with any of that, because that's not what you're interested in hearing from me today. That's lawyer talk, and those are things to defeat a case at an early stage if, in fact, the complaint does not state a legal cause of action against you. But again, that's for your lawyer. That's not for you. Now, I do appreciate there's some pretty smart people out there who do some good lawyering and they've never been to law school. But that is unusual. Get a lawyer. Don't talk to people about the case. Don't talk to your mother-in-law. Don't talk to anybody about it. Gather the facts. Let your lawyer do the job. And you're going to be just fine, other than having some sleepless nights about being sued. That's all I have to say for right now on the issue of you've been sued, you've been served. Freaking out, don't freak out. Get a lawyer and he'll take care of you, or she'll take care of you. So that's it for today's episode of No Holds Barred. If you like it, hit that subscribe button and you'll be notified of future episodes of No Holds Barred. And stay tuned for those episodes.